Please take your seats. Thank you. Good morning, ladies and gentlemen. Caribbean Court of Justice. This sitting is a special sitting carded to mark the retirement of the Honorable Mr. Justice David Hayton, Judge of the Caribbean Court of Justice. Over to you, President.
Yes. Thank you, Mr. Hale. Good morning, all, Your Excellencies, my learned judges, colleagues, distinguished guests. It's a very great privilege and an honor for me to welcome you all to today's special sit-in to pay tribute to our esteemed colleague, Mr. Justice, the Honorable David Hayton. Today, as we formally, not finally by any means, as we formally say farewell and thanks for his service to the court, we also celebrate the enormous contribution he has made. Of course, Justice Hayton demits office in July, and we have thought it fitting that we convene this special sit-in today in his honor. Justice Hayton has been a judge of the court from its inception 14 years ago. This was no ordinary period in the life of the court. These were the formative years, the time when the court took a huge leap forward from being just a vision, a dream in the breasts of proud Caribbean people. It was a time when the court moved forward from being a concept captured in a treaty. It was a time when the dream came alive, when the vision began to impress itself in tangible ways on the legal and judicial landscape of the Caribbean and the wider world. These were the years when the concept took flesh and the court began to dispense justice and affect the lives of people and shape the behavior of states throughout the Caribbean community. It was an excellent thing that Justice Hayton served precisely during this period, because his contribution to this process has been phenomenal. On behalf of my colleagues on the court, on behalf of the entire staff, and indeed on behalf of the region, I offer thanks to you, Justice Hayton, for eschewing the hallowed halls of academia in London in favor of this grand Caribbean project. Justice Hayton came to us as an intellectual of the highest repute. In 1966, he graduated from Newcastle University with a Bachelor of Laws degree. He earned this degree with first-class honors, and in the process won the Reynolds Memorial Prize for being the top student in his year. After graduating, he embarked upon an academic path, serving as a law lecturer at Sheffield University. He sat the bar finals in 1968, and it comes as no surprise to those of us who know him, he was once again the top student in the bar finals examination. He went on to pursue graduate studies and, most notably, became a fellow of Jesus College, Cambridge University, and a professor at King's College, London University. This foundation naturally set the course for David's long-standing career as a legal scholar. To date, he has published countless articles in distinguished law journals and has contributed chapters to many edited collections. He has also written or edited some 15 or so books in areas of trusts, property, succession, and tax law. Many of us in the region are familiar with some of these texts. Some of them are a mainstay and a go-to resource for practitioners the world over in these important and, quite frankly, sometimes complex areas of the law. Up to the time he was sworn in as a judge of the court, Justice Hayton was arguably the foremost authority in the United Kingdom and Europe on the law of trusts. Justice Hayton's dedication to legal scholarship and his in-depth knowledge and expertise qualified him as a distinguished jurist of international repute. He headed the United Kingdom's delegation to the Hague Conference on Private International Law for the Trusts Convention, and the Hague Conference on Succession to the Estates of Deceased Persons Convention. He also served as technical advisor to the International Monetary Fund, advising on offshore financial centers, trust law, and trustee regulation. Any court, anywhere in the world, would be delighted to have such an intellectual giant on its bench. It is no exaggeration to state that Justice Hayton's academic pedigree played no small part in the affirmation of the CCJ by those who assess it on objective criteria. The court, of course, naturally made full use of David's intellect, his expertise, his academic background, and his experience in publishing. When, for example, my predecessor, Sir Dennis Byron, commissioned a project to catalog the work of the CCJ over its first decade of operations, he called on David to head that project. Justice Hayton valiantly took up the mantle, and in 2016, the book, The Caribbean Court of Justice, the first 10 years, was made available for public consumption. Through this work, the people of the region and the world can judge for themselves the manner in which the CCJ has been advancing Caribbean jurisprudence. This project would not have been a success without David's keen stewardship, not only in receiving the chapters and overseeing their editing and compilation, but also in marshalling the publication process and ensuring the timeliness of the project's completion. Justice Hayton also chairs the court's library committee, and he oversees the CCJ's collaboration with the European Commission for Democracy Through Law, that's the Venice Commission, which allows the CCJ's human rights-based cases to be published in the Venice Commission's free access database. The court is also exploited to the full, to the extent to which it is possible within the constraints of a final court, Justice Hayton's interest and experience in grooming the next generation of legal professionals. He has headed the CCJ's legal internship program, which facilitates law students coming to the court for a few weeks each year. He has also been assigned the lead responsibility in recruiting judicial counsel for employment at the court. In addition, he has also been assigned the lead role in the organization of the CCJ's annual International Law Moot, which has been held every year since its inception in 2009, and during which Justice Hayton invariably presided. At these moots, law students from both academic and professional institutions across the CARICOM region annually showcase their skills in legal analysis and advocacy and apply themselves to novel hypothetical cases concerning the revised Treaty of Chaguaramas. In all of these areas, Justice Hayton has provided invaluable service to the court. He has clearly done an excellent job recruiting judicial counsel, because we do currently have and have always enjoyed a first-rate caliber of young counsel who provide critical legal and other support services to all the judges of the court. As to the law moot, well, each year the moot surpasses the successes of the previous year. I have been sitting on appellate courts for almost 2 decades now. I've never encountered a judicial colleague like David. He's always the first to volunteer to write, and when he's assigned to write a decision, he embarrasses the rest of us by producing a first draft well before many of us have had time to read the voluminous authorities cited and referred to an argument. I have to tell you, David, that behind your back we have been referring to you as Speedy Gonzalez. During his years on the bench, David has to date authored a huge number of opinions in the appellate jurisdiction, most of them being judgments of the entire court. These opinions, of course, in the original jurisdiction, the decisions are authored by the court. His opinions in the appellate jurisdiction have spanned the entire gamut, from public to private to constitutional law. I have no doubt that between now and the time he demits office as a judge of the CCJ in July, he may well add 1 or 2 to that number. David has been the consummate team player. If only one judge attended a staff activity, whether a meeting, a briefing, or a pleasurable social event, that judge would be Justice Hayton, accompanied by his dear wife and constant companion. This has naturally endeared him to the staff of the court. Over the last year or so, in many of my speeches, I've been laying out the importance of judges absorbing themselves in the culture of the people whom they judge, and the relevance of such immersion to the adjudication process. When David was appointed a judge of the CCJ, he was already familiar with Caribbean life and culture, having served as an acting justice of the Supreme Court of the Bahamas. I would dare say, however, that during the time he has spent in Trinidad and Tobago, he has truly immersed himself in the cultural life of the Caribbean, and Trinidad and Tobago in particular, to an even more profound degree than many of us who were born and bred in the region. In fairness to my Caribbean colleagues, David was simply trying to catch up. And he more than caught up. With a spirit of adventure and an unparalleled zest for the good life, David and Linda have sampled and enjoyed the cuisine, the nightlife, the carnivals, the beaches, the restaurants, the kaiso and reggae, the rum flavors, the steel band, the cricket grounds, the theater, all the various facets, you name it, that make the Caribbean people who we are. To be quite honest, I would sometimes ask David for recommendations on the best restaurants or entertainment options in the country, and he's never given me bad advice. As an apex court, the work of the CCJ is not confined to the adjudication of cases. It extends as well to various outreach initiatives, such as training judges and delivering lectures, collaborating with judges throughout the region and outside the region. This is done not just at an individual level, but also through organizations such as the CCJ Academy for Law and the Caribbean Association of Judicial Officers, CAJO. Justice Hayton has answered the call whenever asked to participate in any of these outreach activities. He has delivered lectures and facilitated many sessions at conferences organized by the CCJ Academy as well as by CAJO. This tribute to Justice Hayton would not be complete without more extensive reference to his wonderful spouse. This is Linda Hayton. When David was appointed, the CCJ really got two for the price of one. Over the years, Mrs. Hayton has given sterling service to various causes of the court. I can speak in particular from first-hand knowledge of her contribution to the work of CAJO, and in particular the Papers and Panels Committee of the biennial conference CAJO organizes. For months before each conference date, Mrs. Hayton would play a leading role in organizing the panels and discussion subjects, identifying suitable speakers, and patiently following up with them to ensure their attendance. During the conferences, we could always rely on her to ensure that everything went smoothly, that rapporteurs were properly briefed and in place, handouts delivered in a timely fashion, and speakers knowing where to go and when. This year's conference will be hosted by the Belize Judiciary, and as in times past, Linda has been giving herself unreservedly to these kinds of initiatives. Linda, we thank you, and we will miss your enthusiasm, your commitment, and voluntary service. As I close, I cannot help but reminisce. In 2005, David and I, along with the Honorable Mr. Justice Witt, were among the first cohort of judges to be sworn in. In the twinkling of an eye, 7 has been reduced to 2. So it is in life. Time flies. But it has truly been an honor to work with you, David. Your intellect, your legal reasoning, your enthusiasm in undertaking the assignments allotted to you, the alacrity with which you completed those assignments have all enriched this institution and helped to establish its high standards. Justices Anderson and Barrow are not here with us for unavoidable reasons. They've asked me to express their sincere regrets at being unable to be here. And they've specifically asked that I indicate that they join the rest of us in wishing you and Linda the very best in all your future endeavors. We all express our sincere thanks for your immense dedication to the work, vision, and mission of the court. Now, we do have some tributes on video, and the next one is from Lady Mary Haden of the United Kingdom Supreme Court, a dear friend of David's, and I will ask our technician to allow us to see that tribute.
Good day, everyone. Some years ago here in the UK, there used to be a television programme, This Is Your Life, when the host, Eamon Andrews, used to present biographical documentaries. The idea was to have a special guest and to take him or her through their life's achievements with the assistance of what was called the Big Red Book. Normally, this was compiled without the special guest's knowledge. Indeed, the special guest usually didn't know that the program was going to take place until they found themselves walking onto a TV set. In turn, I prepared this tribute without Justice Hayton knowing what was going to go in it. But there would have been too many pages in your Big Red Book, Justice Hayton, for even Eamon Andrews to turn them all. Variety, speed, and productivity are the hallmarks of your career. Your early years were spent in the northeast of England, and then you went to university in Newcastle upon Tyne. I will not recount all your academic achievements, but you did your PhD in Cambridge, my university, and my college, Girton College, tells me that you acted as Director of Studies for some months. From all accounts, you were a popular and valued lecturer in law. As author or editor, you have produced at least 15 books on trusts, property, succession, and tax, and published over 50 papers. What a record. When you were an academic, you also managed to practice as a barrister. That must have cost you a great deal of shoe leather, and in due course, it must have earned you a lot of air miles, because you rapidly became the world's expert in cross-border issues relating to trusts. In addition, you became the UK delegate for the Hague Convention on the law applicable to trusts and their recognition, that was 1984, and the Convention on Succession to Deceased Estates in 1988. Your writings on cross-border issues relating to trusts have greatly assisted the practicing profession in many jurisdictions. You must have helped many to preserve their family wealth or to carry out financial transactions more effectively using the trust vehicle. We owe you much to your hard work on trusts. My particular memories go back to when I was chair of the Law Commission of England and Wales, and you were then deputy chair of the Trust Law Committee. You held that office for some 11 years. The committee was highly influential and provided much valuable input on trustees' powers of delegation and investment and on the apportionment of capital and income. In both cases, the Law Commission's subsequent reports led to new legislation in the UK. There were other eminent individuals who were involved, but your contribution was enormous. The academic who becomes a successful judge is to be compared, as I see it, with the philosopher kings of ancient times. They were reputed to make the best of kings. It may be that you were attracted by the role of telling truth to power. This is a challenge for judges the world over. I was reminded of this recently when I visited Potsdam, the home of the Kaisers. Frederick the Great Prussian king in the 18th century, built himself a most splendid palace, and he built it very close to a windmill. He assumed that the owner of the mill would move his mill when he built his palace, but somehow that didn't happen, so he called the miller before him and said, "Miller, don't you know that I could just get your mill removed to some other place? Why don't you just move it?" And the miller calmly said, "Your Majesty might do that, but for the Court of Appeal in Berlin." So the mill was never moved, and it remained in its original position. An independent judiciary is essential for the maintenance of the rule of law, and it is the cornerstone of the modern democratic state. The next pages in the Red Book see you continuing to work on trust law. Like me, you are a bencher of the Honourable Society of Lincoln's Inn, and I have the Treasurer's permission to welcome you back there on your return. The Inn has recently built a new educational suite for bar students, thus strengthening and enriching its long-established educational function. I hope you will contribute to the Inn's important educational work. I somehow think that with the habits of 14 years in the Caribbean, you will also continue to follow, as you always have, the sport of cricket. I hope cricket will be one of the many pleasures that you will have, and that you and Linda will enjoy long, healthy, and happy lives. I would like to thank the President for the opportunity to make this tribute. Thank you. Goodbye.
We thank Lady Hayton in her absence. And we do have another tribute by video from the Honorable Mr. Justice Paul Matthews from King's College London, who is a co-editor of the book Underhill, the book on trusts by Underhill and Hayton. So we'd ask our technician to line this up.
Mr. President, Justice Adrian Saunders, Honourable Justices of the Caribbean Court of Justice, distinguished guests, ladies and gentlemen. I am very sorry not to be able to be present with you on this happy occasion. Happily, however, modern technology allows me to present this short message together with my good wishes. I was a law student in the 1970s, a time of social turmoil in the United Kingdom, during which Britain negotiated to enter the so-called European Common Market, and the civil side of the English legal system was presided over by Lord Denning, then scarcely even into his second wind. Naturally, therefore, I gravitated towards trust law as my favourite subject, where I kept encountering the name of Hayton. It was on all the chunky articles and even some of the books. I did not know who this Hayton was, but evidently he was a big beast in the legal jungle. I first met David, he won't remember this, in 1980 when he was lecturing to students on the bar vocational course in conveyancing, and I was one of his students. Like everyone else, I was hooked by his lecturing style. That's the way the mop flops and the cookie crumbles, you shyster, dum dum dum. Apart from that, I was astonished to find a trust lawyer who could also do conveyancing. But I came to realise later that David could do virtually anything. He was a sort of legal multi-strike weapon. I became a lecturer at UCL, specialising in trust law. So from time to time, David and I met at conferences both in London and abroad. I have a memory on one occasion of running alongside David around the quaint little streets of Luxembourg City, trying to keep up with him. Tall men just do not realise how hard it is for short ones. We had a number of friends in common, including the late and much missed Tony Oakley, who had in fact originally taught me trust law as an undergraduate. Eventually, I left UCL to go into practice, but after a few years I got bored and I thought I would like to do some part-time teaching as well. So I invited David to a rather agreeable lunch at the now vanished Hodgson's in Chancery Lane. It was about 1990. By the time lunch had finished, it was about 1991, and David had agreed to get me some part-time teaching at King's College London, to which he had moved from Cambridge a few years previously. I found the atmosphere at King's College very congenial. David was especially congenial. He held wine tasting sessions in the law school staff room, known as the parlour, and in addition there were drinks in the pub, dinners in Tony's Vino bar on the Strand, no longer there alas, and lunches in Rules, happily still there. So naturally I began to stretch my teaching hours as far as I could, compatibly with my practice. In 1995, David and I launched a new module in the LLM degree course in International and Comparative Trust Law. So far as we know, it was the first course of its type in the world and has since been much copied. It is still being taught at King's College nearly 25 years later, and the convener is Filippo Nozeda, a former student of the course. The 10 years that we taught together on this course I regard as the best years of what might loosely be described as my academic career. On the other hand, the infrastructure of the law school itself was in a poor state. I well remember that during the rainy season, David regularly had buckets placed at strategic points in his office in order to catch the leaks that came through the ceiling. In 2005, of course, David left King's College to join your court. Our loss was your gain. Indeed, your gain must have been enormous because our loss certainly was. I was on the panel to appoint a successor to David. His shoes were so big to fill that we ended up appointing not one professor, but two, namely Robert Chambers and James Penner, who have both gone on to become stars in their own right. I succeeded David as deputy chairman of the Trust Law Committee. He also let me have many of his old trust law books, which are still at King's College and available to my colleagues. Even though now located in very different time zones, we still managed to collaborate. Charles Mitchell and I joined David in editing the major practitioner work Underhill on Trusts and Trustees, now justly retitled Underhill and Hayton. We have so far done 3 editions together, and I'm sure there will be more. David and I have continued to share conference platforms together in many agreeable parts of the world, including Geneva, Naples, and even on one occasion, Beijing. During that last trip, I have a very happy memory of one day visiting the grounds of the Imperial Summer Palace on the outskirts of the city, and whilst exploring the gardens and making my way carefully up a flight of steps between the bushes, meeting David and Linda coming down. Small world indeed. Mr. President, I wish David a long and happy retirement with lots more conferences and trips around the world and many more editions of Underhill and Hayton.
And we thank Mr. Justice Matthews for that wonderful tribute. We were having some difficulty with the video from Sir Dennis. Madam Registrar? Okay, so then we would call on you, Dr. Berry. Please come to the podium.
Honorable Justice Mr. Adrian Saunders, President of the Caribbean Court of Justice, Honorable Justices and former Justices of the Caribbean Court of Justice, Your Excellencies, other high-ranking dignitaries, learned friends, esteemed colleagues, ladies and gentlemen. It is a great honor to be able to speak on this ceremonial sitting of the Court to mark the retirement of the Honorable Mr. Justice David Hayton as Judge of the Caribbean Court of Justice. I have come to know Justice Hayton following his appointment to the bench of the CCJ. I have had the privilege of appearing before him in court, working with him in a small way on his publication, and liaising with him on international mooting. Each of these experiences demonstrates something about Justice Hayton's character and achievements. Firstly, as a Justice of the CCJ, let me mention the original jurisdiction case in which I appeared as counsel before him. This case raised considerable regional attention and involved numerous video conference hearings, 2 evidential hearings, and a final hearing on the merits here in Trinidad and Tobago. Throughout our many appearances before the court, I was struck by Mr. Justice Hayton's fine eye for legal and factual detail. I was also struck by his ability to get quickly to the central point of submission. He was also, perhaps unfortunately, quick to show when arguments were not persuasive. And I remember watching his expression carefully and sometimes with dismay as our arguments were not accepted. Having subsequently become more familiar with his legal career, I now understand that this rare combination of being able to see the big picture and yet still having an eye for critical details may have grown out of Justice Hayton's many years' experience as a renowned legal academic, combined with a strong legal practice, particularly in the area of law of trusts. Secondly, as editor of the CCJ's the first 10 years, Justice Hayton's critical eye was, again, perhaps unfortunately, applied to my academic work when I was invited to write a chapter in his publication, The Caribbean Court of Justice, the first 10 years. Justice Hayton served as the general editor of the book and was relentless in following up on the progress of my chapter and in encouraging me to develop and strengthen my work. Luckily, his energy and enthusiasm for this project were contagious, and I greatly appreciated his constructively critical feedback. The book represents a timely snapshot of the CCJ's first 10 years of jurisprudence, one which must serve and will serve as an important historical record of this seminal period of the court. He must be congratulated for having the vision to create such a book and for his hard work in bringing it to fruition. Thirdly, as organizer of the Caribbean Court of Justice Moot Court Competition, in another capacity of mine as administrator, faculty administrator, I've enjoyed interacting with Justice Hayton in relation to the CCJ's Moot Court Competition, and his achievements here must be highlighted as well. The CCJ's competition is a very important regional event. It has become the site of what might be called a yearly pilgrimage for many students from the law faculties and law schools of the Caribbean. Its rigorous oral rounds have trained a cadre of young minds not only to understand, but also to apply the revised Treaty of Chaguaramas and the original jurisdiction jurisprudence of the court. I am delighted that this competition has done so well over the years and extend my heartiest congratulations to Justice Hayton and other members of the court on this achievement. Finally, I would like to comment briefly on Justice Hayton as reformer and innovator. In relation to his judicial writings, and I reviewed all the cases of Barbados for the first 10 years, and so had the opportunity to read many of his writings, it would be remiss of me not to highlight in one of his many useful contributions, Justice Hayton will be, to remark upon one of his many useful contributions, Justice Hayton will be making to our regional jurisprudence. I say will be making since we have not yet implemented a suggestion he took part in making in two 2011 appellate jurisdiction decisions from Barbados. These are the cases of Colby and Felix Enterprises and Sea Havens Incorporated and Dryud. The suggestion made by the CCJ was that regional practitioners should develop conditions of sale for conveyancing, similar to English national conditions of sale or law society conditions of sale, that all English practitioners incorporate into their contracts for sale of land. Such a suggestion was pertinent to both the Colby and Sea Haven cases, since both involved parties who were, to put it mildly, greatly confused about their legal obligations in relation to sale of land. The Colby and Sea Haven cases involved contracts for the sale of land to a lessee slash purchaser, which allowed credit for rent paid towards the purchase price. In both cases, following disagreement about obligations on the part of vendors and purchasers, the vendors sought to rescind the contract and keep the deposit, and the purchasers sought specific performance. This disagreement about legal obligations on the part of the parties led the CCJ in paragraph 1 of Colby to state, and I quote, "This vendor-purchaser dispute involving a contract for the sale of land ought to have been a relatively straightforward one. Matters, however, became complicated due to delays of the parties and the courts, and due to the absence of detailed standard conditions of sale containing clear and comprehensive provisions governing the process through to completion or termination of contracts for the sale of land. Conveyancing in Barbados would be much simpler and quicker, and recourse to the courts very much less, if a small working party of experienced conveyancing attorneys could prepare a set of standard conditions to be incorporated into land contracts, except to the extent expressly modified with special conditions to cover the exigencies of a particular sale." Similar wording is found in paragraph 1 of Sea Haven. These two paragraphs are a fine example of a court speaking directly with practical and helpful advice to the legal profession. The CCJ gently asked us to amend our ways. I am sure we will do so shortly. In conclusion, I congratulate Justice Hayton for his persistent efforts at Caribbean legal development and legal reform. We will miss his voice over the coming years, but perhaps we can take some solace from having the benefit of his many excellent judgments and other writings to guide and encourage us. My lords, it has been a pleasure and an honor to speak at today's ceremony. I thank you and know that all here will join me in wishing Justice Hayton happiness and success in the next part of his journey. I thank you.
Yes, thank you very much, Dr. Berry. Professor Antoine.
Mr. President, honorable justices, ladies and gentlemen, good morning. For a new court emerging from what is often labeled as third world, wanting to announce its competence and neutrality, it would have been considered prudent to signal its intention to follow international standards of judicial making. One way of doing so was by identifying a well-established international scholar of impeccable credentials to be part of this judicial body. This special role fell to our then Professor David Hayton. It was for the same reason that the CCJ's builders insulated the judicial selection process from all political influence, establishing a mechanism, the JLSC, that would, ironically, attract the highest praise from the international judicial community for its impartiality. I have no doubt that today, 15 years after its inception, and enveloped by an outstanding body of jurisprudence and enviable reputation for impartiality, this need to assuage those fears is no longer present. But this was no token foreign judge. Hayton came to us at the very top of his field, having been promoted to the rank of professor at King's College, a rank reserved for the heights of academic excellence in the UK as in the West Indies, and with an international consultancy base, practice, and a leading author on domestic trust law. He was also grounded in the Caribbean, having done much work on the international financial sector here, and sat as an acting judge. Hayton brought a wealth of experience and expertise in commercial law to the CCJ, especially trust and property law, and I have observed often wrote those kinds of judgments, some which involved our most important corporate institutions, such as Clico, Sagicor Insurance, and Belize Bank. A court of this high standing requires a mixture of generalists and specialists, a good balance of purist practitioners of high quality and leading scholars. For me, Justice Hayton's presence was a personal blessing, given my own work in what I have labeled offshore financial law, a field, though of immense significance in the region and tremendous international import, in which I had little company. He graciously provided a foreword to the second edition of my Offshore Trust and Tax Issues in Offshore Financial Law text. Our paths also crossed when we were both selected as among the 8 honorary fellows of the International Society of Trust and Estate Practitioners, the only worldwide body in this field. Imagine my pique when I, believing myself to be the only person from the Caribbean, saw Justice David Hayton, also listed as Caribbean, not UK. But of course, I was proud to claim him as such, since he had earned his credentials. The quintessential scholar, Professor Hayton had started off with a heavy dose of skepticism about the offshore sector, and in particular offshore trusts, which I have characterized as hybrid trusts. Indeed, his article questioning whether this trust was indeed a true trust caused quite a stir and quickly became a must-read, even from those like myself who disagreed with this view. Yet he came, dare I say, full circle, and he was to include discussions of this hybrid offshore trust as a legitimate entity in later editions of his authoritative trust books. This openness to new knowledge and views, and the ability to assess objectively, to come to truth, was a deep asset to his task as judge in a court that was to face a number of judicial puzzles in landmark cases over the years. I acknowledge too his motivational work with our students through the moots. He would have brought to each of his cases that intellectual vigor, discipline, and piercing analytical inquiry, that is the hallmark of a top-class academic, with an overlay of understanding of legal practice and policy. I know that his leaving will be a great loss to the CCJ, and his will be huge shoes to fill. On behalf of the Faculty of Law, UWI St. Augustine, it is my honor to thank you, Honorable Mr. Justice David Hayton, for your service to this esteemed court and region for the past 15 years, and wish you the very best as you continue your journey. You will remain forever as one of the distinguished forefathers of the CCJ, helping to build this formidable institution at perhaps its most important moment in time. I have no doubt that while retired from this court, you will continue to enrich this region through your writings and consultancy work. So, adieu and Godspeed. Thank you.
Thank you, Professor Antoine. We have another tribute by video from Dr. Peter Menard, and I will ask our technician to cue it up.
Mr. President, my lords, my lady, and through you, distinguished ladies and gentlemen, friends. To quote George McHenry, retirement is not an end, but a new beginning. It's a time to stop living at work and to start working at living. I hope this will be a great new beginning for David and also for Linda, who in her own right is a very able lawyer and has been a tower of support for David. I first met David some 43 years ago when I arrived at Jesus College, Cambridge, to continue graduate studies in international law and to qualify for the Bar of England and Wales. David was my tutor and lecturer in the law of trusts. He could explain the most arcane and mysterious concepts to his students with such confidence and clarity. Of course, much water has passed under the bridge. By then, you've seen his sparkling resume. He's made stellar contributions, not only in writing, legal education, but also on the bench and in practice. He's also participated in some of the major judgments, both appellate and original judgments of the CCJ, and has contributed tremendously to building the CCJ as an institution. He's also a very competitive person, and so I'm looking forward to meeting him not only on the squash court, where he spared me just a few points, but also in a table tennis game or two, which may be out of his comfort zone and certainly within my comfort zone. David has contributed immensely to the credibility, regionally and internationally, of the CCJ. He's made so many contributions through, in other ways, through spearheading, for example, the CCJ moot. I wish him and Linda the very best in the future, and hope that they will make the most of this new beginning. Thank you.
We thank Dr. Menard, and I call on our registrar, Ms. Jacqueline Graham.
Mr. President, honorable judges, former judges of the CCJ, distinguished guests, colleagues, friends, on behalf of every staff member of the court and the Secretariat of the RJLSC, I seek your indulgence to pay tribute and bid farewell to the Honorable Mr. Justice David Hayton, Judge of the Caribbean Court of Justice, bencher of Lincoln's Inn, and Fellow of King's College, London. Justice Hayton, in this celebration here today, we applaud your achievements and express satisfaction in having shared with you some of the encounters and experiences you've had here in Trinidad and Tobago. This event is indeed a sobering moment because for us here at the court, if we have up until this moment considered that business will continue as usual, we are confronted now with the reality that you are moving on from us and entering a most delightful phase of your life. It has been a signal honor to have benefited from your wisdom, your guidance, your humor. Many of us enjoy saying to anyone who would listen that we have the foremost authority and trust sitting on our bench. There are others of us who would boast that you were a professor at King's College and that you have authored several books and have become reference texts for practitioners, students, and universities around the world. At the CCJ, from the most junior member of staff right up, we have been proud and honored that you serve with us. Just by being who you are and because of your many achievements here at the court and otherwise, we say thank you. Let me just share with you a few of the remarks made by staff members as we considered your retirement from this court. Justice Hayton would have made a great storyteller, considering how he read his judgments, with intonations, drop and rise in voice pitches, never a dull moment listening to him read a judgment. For the mood competition, he made the mood registry staff feel as if they were in their classroom, as he was very down to earth in dealing with them. He has been very pleasant to registry staff, jovial and easygoing, a true gentleman. Never missed the CCJ functions, especially Panyard Crawl for Carnival. He loves pan music, performing and dancing, loved the soca. He's a very nice judge, is always happy, loves to work, as well as to go out and have a nice time with Mrs. Hayton. Pan, movies, the theater, carnival events, tennis. As a matter of fact, any event where there's a good line. A gentleman in all your dealings, we take a moment to say to you, Judge, we appreciate you. We feel that the benefit has been ours, that you chose to be here at the CCJ, and we thank you most sincerely. On behalf of every staff member of the Caribbean Court of Justice and the Secretariat of the Regional Judicial and Legal Services Commission, I extend to you, Mrs. Hayton, and your family, warmest wishes for your future. May you enter a most incredible period of your life. The iris saying their farewell. May the road rise up to meet you. May the wind be always at your back. May the sun shine warm upon your face. The rains fall soft upon your fields. And until we meet again, may God hold you in the palm of his hand. It is in this vein we add, may you welcome with joy all your wonderful new surprises. May you see them, hear them, and feel them, and celebrate fully the riches of all your new adventures. Thank you so very much.
Thank you, Ms. Graham. Mr. Prescott from the Regional Judicial and Legal Services Commission. Yes, Mr.
President,
Prescott.
thank you. Honorable judges of the CCJ and the Honorable Mr. Justice Hayton and distinguished guests of the court, I thank you very much for the opportunity to speak on behalf of the Regional Judicial and Legal Services Commission, of which I am a member, and on their behalf to offer the very best wishes to the Honorable Mr. Justice Hayton on his departure from this bench, and to his wife, who I learned has been his companion and continues to be so. And so his future is assured in that there will be a woman standing behind him or side of him, alongside him in the years to come. I had not heard of Justice Hayton in any real sense, except that I had been familiar with the law of trusts and the texts by Underhill and Hayton. And incredible as it may seem, I have come to Trinidad and Tobago to discover that the learned author is present among us. My first sighting of him was at the meeting of the Regional Judicial and Legal Service Commission, when he presented on judges' pensions. And I was alarmed at the youthfulness of the revered author, because I thought the book was quite old myself. Justice Hayton, today several encomiums have been heaped upon you, none of which would have surprised you because it's part of your history. But insofar as you have led developments in the Caribbean, and I refer to the Moot Court and to your authorship of judgments, etc., and guided us over the years, we in the Caribbean are much the better for it, for the invaluable work that you have done. Your influence in education, your teachings, from what I have heard, are memorable and are developmental for all of us. And one can only assume that as you embark on your new life, that you will not desert those paths that you have followed. Forgive me if, as a lawyer who ought to know his silk, if I make this error, but insofar as you've excelled reportedly in trust and succession, and insofar as politics and the world of the law are parallel universes, if you should return to the UK at this time, you may find that matters of trust and succession are very much on the table, but in politics. And I am sure that somebody will be aware of your return to that country and may find that they need your guidance in the years ahead. May God bless you as you proceed on your new life. And may we always in the Caribbean have the opportunity of welcoming you back, because it seems that you have found the culture. And I've been told you've immersed yourself in the Trinidad culture in particular, so that we look forward to your many returns to this country. Thank you very much.
Yes, thank you, Mr. Prescott. The person among us who knows Mr. Justice Hayton and his family, I think, best is his driver and usher for the last 14 years. And it is only fitting that we've asked Mr. Oscar Peters to also say a few words.
Morning to all. Morning, Mr. President, judges, guests. It's an honor to have you all here this morning to enjoy this day with Justice Hayton and his friends and family. This is a day, Justice Hayton, be glad and rejoice in it. This is your day. It's an honor to be a driver. I was introduced to Justice Hayton in 2005 by Mr. Nigel Payne when he used to live at Marval, Mocha, up Marval side of the golf field. And while I was introduced to Justice Hayton, I was a prison officer in Antigua. I accustomed carrying inmates to court and different things, They know much about the law. And when I was introduced by Justice Hayton by Mr. Nigel Payne, and I watch the size of the person come outside, I say, wow. Now, if there's any trouble, how can I bundle this man into a car and get rid of him? So I say, it's either he bundling me and he's driving off. Well, he's been an icon to me. He's been a father to me. Now, I leave my tears home. I did it last time, so I say a little horse. And he's been everything to me. His wife as well, Mrs. Linda Hayton. I've been a family to them. They didn't really look at me as a driver. They look at me as family. I mean, I've been loved by all the judges, but I've been loved more by Justice Hayton. So I really appreciate being there with him, guiding him, protecting him, make sure you reach him safe, he and his wife. Now, as I spoke about the family part, I mean, at one time, Mrs. Hayton wanted to go out, and her son was kind of keeping us back, and she'll turn to me and say, Oscar, you need to talk to John. You know, and I go along and say, John, we need to leave immediately. And immediately, whoever hole he was in, he fly out. And that shows they didn't look at me as a driver. They look at me as family. And I really appreciate that, you know. And look at Sandra, John Hayton, stand up like this. So, it's been an honor, Mr. President, to stand here before this woman. I've always wanted to stand here, always. I see the lawyers came up here and stand here and put across the case. And I
You always thought you could do a better job, didn't you?
But the one thing I'm going to miss the most is that we come down in the vehicle together, we'll talk, make jokes, you know, laugh, talk about laws and different things. I had 3 matters before the magistrate court with 2 speeding and 1 without a seatbelt. Well, it was my fault, you know, when the judge called, I have to be there. You know, and that matter I had before the court, I win all 3 through Justice Hayton and Mrs. Hayton. I listened to them how to guide me on law, how to go about presenting their matters and different things, you know. Mom and Justice Hayton, I call her Mom, Mrs. Hayton, right? They guide me well, so I learn a lot. I learn a lot from them. I'm going to miss him very bad, you know, being as an icon to me and standing there with me. I mean, rise and fall, he's always there, always want to listen, chat to me, you know. He's a special guy, special guy. As Justice Pollard said, that is a brilliant man. I will never forget that. He said, a brilliant man. I said, yes, Justice Pollard, I know. Judge is so happy to be in your family and being there for you and you being there for me and guiding you all and protecting you all home safely. Even though when John come to Trinidad and him alone here and his wife and his mother and father is out, I will call John 5 to 4 times for the day. I say, I don't want to hear your father come back home here and say something happened to you. I want to make sure that you are there and you are well when they reach back home in their hands. Well, I go on. I'm very thankful for the President for having me here as well too and giving me this special time to give my part of the story as well. And thank you all very much for accepting me in the CCJ. And I love it here. The CCJ is a family and I hope we stay that way and invite other people to know about the CCJ and keep it rolling on. Thank you all very much.
Thank you very much, Oscar. Mr. Peters. And we've gotten to that point in time where we wish to hear from the man of the hour, David himself.
Well, Mr. President, Your Excellencies, learned judges, and other distinguished ladies and gentlemen, let me express my heartfelt appreciation for your presence on this special occasion, and for the over-generous remarks of those who have earlier spoken. Indeed, I've been overwhelmed by the response to what I consider to be merely getting on with your job, although, as my mother used to tell me, if a job is worth doing, it is worth doing well. So, as one of the original self-styled Magnificent 7 judges appointed 14 years ago, and as an Englishman with a stiff upper lip trying to avoid emotional occasions, I'd hoped to ride quietly off into the sunset. In the end, however, the weight of my colleagues' wishes prevailed over my personal wishes, so here we are. And what a 14 years it has been, after leaving everything behind in London for a brave new Caribbean world. Has it been worth it? It certainly has. It's been an absolute honor, a privilege, and a delight working in the CCJ these last 14 years. After extensive advertisement in the common law and the civil law world, it was an honor to be selected after interview by the Regional Judicial and Legal Services Commission. I remember 8 of us flew over on Biwi on a Saturday. We were shown round a bit on the Sunday and even taken for a trip to the zoo. But on the Monday we were interviewed, and then on the Tuesday we were all sent back to await the outcome of the interviews. It so happened, of course, there'd been a lot of other Caribbean persons interviewed the preceding week, including a Dutch judge working in Curacao. And as we all know, Justice Witts and I were fortunate to be appointed to the CCJ bench We believe in the RJLC's belief this would afford extra breadth to the range of experience already represented on the bench by Caribbean legal luminaries. The idea, and we hope it was fulfilled, but it's not for us to determine that this would contribute to the quality of judgments. But as I say, it's for everyone to judge in the light of over 196 appellate judgments and 27 original jurisdiction judgments on our website, and there's some significant judgments that are going to be delivered in the next 6 weeks or so. It's, of course, a very privileged position to be on the CCJ bench to serve Caribbean peoples, whether it's pursuant to the court's central original jurisdiction role to flesh out and to police the skeleton structure of the revised Treaty of Tragaramas, or pursuant to the court's extensive role in its appellate jurisdiction to develop the domestic laws of CARICOM states as most appropriate to the circumstances of those states. And both the appellate and the original jurisdictions really should contribute to developing the wealth and happiness of Caribbean peoples under a rule of law promoted in the constitutions of CARICOM states. Now, what some people overlook is the 12 member states are fully subject to the CCJ's original jurisdiction already. And this is broader even than the jurisdiction of the European Court of Justice, because the CCJ has the power to interpret and apply the treaty, except in referral cases by local courts to the CCJ under Article 214. The ECJ can only interpret its treaty and then send the case back to domestic courts to apply that interpretation. And what's been particularly significant in the region, I think, is that member states have fully complied with a very extensive range of remedies that we have developed in the CCJ, despite practical problems that could have been created, of course, over the enforcement of international law judgments. But indeed, in a Belize case involving the rights of the indigenous Mayan people, the court ordered Belize to provide a fund to enable the government and the Mayans to work together towards establishing a statutory machinery to determine Mayan land rights. Moreover, the court retained a monitoring function to assist both sides continuing to work towards reaching satisfactory compromises in developing some statutory machinery. Some other highlights to look back on concern the exercise of the original jurisdiction, where we held it extended to cover companies having treaty rights against their own state, as well as against other member states, the enforcement of an effective common external tariff to help the development of small and medium Caribbean enterprises, subjecting CARICOM institutions to a judicial review process, and of course nationals of CARICOM states having automatic rights to a 6-month stay in CARICOM states unless undesirable persons or likely to be a charge on public funds. In the appellate jurisdiction, some of the highlights are the development of civil liability as well as criminal liability for misfeasance in public office, the need to take full account of time in custody on remand when sentencing convicted criminals, the unconstitutionality of a mandatory death sentence for murder, and the possibility, despite the contrary view of the Privy Council, for the Savings Clause provision in a constitution not to prevail where inconsistent with fundamental rights, the development of the scope of constitutional rights to the protection of the law, the refusal on grounds of public policy to enforce an arbitral award in Belize when based upon a contract entered into by a government in breach of the separation of powers of the executive and the legislature, the 2 terms maximum for the presidency of Guyana, the clarifying of Guyanese Roman Dutch land law, where you can't have equitable interest, sadly, and clarifying Barbados conveyancing law in the absence of proper conditions of sale, as Professor Berry mentioned. And then an odd but interesting case where we stayed murder proceedings against the accused until provided by the state with the reasonable fee required for the accused to hire a forensic odontologist to deal with the state's odontologist evidence as to bite marks on the victim's body. And then currently, I think we're all aware, we're working on 2 critical judgments concerning the appointment of the chairman of the Guyanese Electoral Commission and the validity or otherwise of a vote on a no-confidence motion in the Guyanese National Assembly. So what cases for me to finish my career with? Now, in both the original and the appellate jurisdictions, the most impressive development, I think, has been the development of an electronic filing system under the leadership of Sir Dennis Byron, our last president, and based upon the courier system. And that, of course, was actually produced by a Caribbean team working for Cortex Inc. and is tailored to the needs of Caribbean courts, we judges and registry staff having put hours of input into ensuring that it met our particular needs. And the beauty of this electronic filing system is it saved a huge amount of money that was previously spent on photocopying paper and on supporting FedEx or DHL in transferring weighty documents to Trinidad from other CARICOM jurisdictions. But the major thing, of course, is it also enables attorneys easily to file documents from wherever they happen to be, and which the CCJ can manage in making arrangements for a speedy trial of the disputed issues, and often, of course, using video conferencing to keep costs down. And when you think about it, without the e-filing system, we would never have been able to deal with Professor Ventos's application to get put on the electoral roll in the Barbados general election. We received the papers by e-filing about 5 o'clock on a Friday after the court had closed. We had case management on the Saturday. We met up on the Sunday and heard the case, decided it, and made an order so that on the following morning, the electoral registration officer had to register Professor Ventos. So what wonderfully quick, speedy, efficient justice there, made possible by the IT that we had developed. Nevertheless, of course, despite all these achievements, it's a disappointment, particularly after all these 14 years, that only 4 CARICOM countries, Barbados, Guyana, Belize, and Dominica, have so far implemented the 2001 agreement establishing the Caribbean Court of Justice by enacting legislation to adopt the appellate jurisdiction. However, one good thing has come out of this. It's given the court the time and the opportunity to take on a special role as the apex court situated in the Caribbean to try to improve the efficient delivery of justice in the region. And of special significance is the Jurist project funded by 20 million Canadian dollars and implemented by the CCJ on behalf of Global Affairs Canada and the Conference of the Caribbean Heads of Judiciary, with which we work very closely, of course. And the project is working with judiciaries in the region to improve court administration and strengthen the ability of the judiciary to resolve cases fairly and efficiently. Its initiatives include the development of model guidelines for the treatment of sexual offences, the setting up, indeed, of a sexual offences model court in Antigua and Barbuda, and the provision of a criminal magisterial bench book for the region. And CCJ judges have also led training programs in the region as to civil procedure rules and processes for clearing backlogs of cases, while also encouraging, of course, the use of electronic filing systems in local courts. And the CCJ itself has an educational arm now operating as a company, the CCJ Academy of Law, which has put on 5 biennial conferences. Its mandate is to provide informative and innovative perspectives on the rules and roles of law, particularly international law, while also providing a platform for examining court administration and encouraging best practices in the judicial administration of justice. The court also established the Caribbean Association of Judicial Officers for the further development, enhancement, and progression of judicial services in the region, with 5 biennial conferences held so far. So we've really been stirring things up in the region to improve the efficient delivery of justice. My hope, therefore, is that once politicians and Caribbean peoples appreciate what the CCJ has been achieving, there will be a readiness to accept the CCJ's appellate jurisdiction, especially when there's also an appreciation of how significant is the role of the final appellate court as the interpreter of a state's constitution. The late Professor McIntosh often rightly endorsed the following statement of the Bishop of Winchester: "Whoever has an absolute authority to interpret any written laws, it is he who is truly the lawgiver to all intents and purposes, and not the person who first wrote them." Now, the most fundamental laws as to rights and freedoms are found in the constitutions of Caribbean states, that's function is basically to provide the blueprint for the rule of law that buttresses living standards in a democratic state. Do Caribbean peoples really want the UK Privy Council to have the last word as to the right course for the development of their fundamental rights and freedoms under their constitution? How long will the Privy Council continue to control Caribbean legal development? Surely it is right for the Caribbean Court of Justice not only to have the final word on interpreting and applying the revised Treaty of Tragaramas, that's the written constitution of the Caribbean single market economy, but also the final word on the interpretation and application of CARICOM states' written constitutions, including ruling, of course, on any interaction between the regional constitution and the state's constitution. Although it seems that all CARICOM states accept the trustworthiness of CCJ judges in the original jurisdiction, you still have some people leaping up and about in some of our sessions in Antigua and Grenada saying, we can trust the Privy Council judges, but we can't trust CCJ judges. Well, the Right Honourable Michael de la Bastide and the Right Honourable Sir Dennis Byron were Privy Council judges. Did they suddenly cease to be trustworthy when becoming CCJ judges? Why on earth should CCJ judges be prone to corruption or to be influenced by politicians? Incidentally, I believe you'll find that before the CCJ, it just so happens that governments have lost more cases than they've won. Now, we CCJ judges enjoyed legal practice, but we've devoted ourselves not to making money as attorneys, but to serving our people by developing the rule of law in the sincere belief that this will enable people to have fulfilling lives in a democratic society. In a sense, we are the archpriests of the law, and to doubt the integrity of the court for the sole reason that its judges are, for the most part, from the Caribbean is utterly absurd. It reveals a totally unjustifiable, insecure self-depreciation, which is wholly unfitting for a region rich with culture, academics, and prominent jurists who have served in high positions all over the world. When people write letters to newspapers, driven by whatever odd motive, erroneously to claim CCJ judges cannot be trusted, their judgments are so weak that most will be reversed by the Privy Council without the opportunity, unfortunately, it's not for us to respond, but for local lawyers or leading citizens to provide a corrective view. Once the public becomes properly informed as to the independence and integrity of the CCJ and the significance of many of its scholarly, original, and appellate jurisdictions, and its outreach work as the region's apex court, a movement ought to develop for the successful accession of states to the appellate jurisdiction. To end on a high note, it has been an absolute delight working with my colleagues on a wonderfully wide range of issues. After hearing a case, we've enjoyed kicking ideas around on the submissions we've heard and determining how best to develop a fair result, fulfilling what can be identified as the purposes of the relevant law. Inevitably, in some cases, there's good scope for sensible argument on both sides, but only one side can prevail. Normally, we do come to the same conclusion, if by different routes sometimes, but there are a few times when there is dissent. However, we're a close-knit group, and we accept this in a good-humoured, well-managed fashion. We've developed as a good team, absorbing new members into the team philosophy and well assisted by a delightful group of judicial counsel. I shall really miss the banter, the bonhomie, the camaraderie of my colleagues, whether working in the CCJ or, for some of us, still playing on the tennis courts. Working with my colleagues to resolve complex issues has been a delight. Having both the original jurisdiction and the appellate jurisdiction, I cannot think of any better job in the world. I thank my lucky stars. I applied for the CCJ when my wife actually brought the advert in the New Law Journal to my attention, pointing out, well, your stints as an acting Supreme Court judge in the Bahamas in 2000, 2001 may help. And of course, it's buttressed by sitting as a part-time judge in London since '84, so give it a go. The RJLSC might just get round to appointing you. And it did appoint me. And I still have to pinch myself to see if it really happened. Is this a real ceremonial sitting or a mythical ceremonial sitting, my honour? What an unbelievable life it is. I thank you all for your attendance today, now making me truly believe in the reality of it all. Thank you very much indeed.
Thank you very much. Now, I know that some people have a rule that you shouldn't have drinks before noon. So by order of the court, we are going to deem this time to be post-noon, to be afternoon.
The sun is over the yard arm.
And I would like to invite you all to have just a few drinks with us and with David and his family. Before I rise, it would be remiss of me if I did not acknowledge and welcome the presence of two of that cohort that Justice Hayton referred to as the Magnificent Seven. Of course, I refer to Justices Nelson and Menard. And I trust that they too will be able to join us for drinks. Thank you very much.
All right.